Good afternoon, Your Honor. Michael Esposito, the Real Water Defendants. Your Honor, just as a housekeeping matter, I'm glad that we started off by discussing the limitations of the motion for summary judgment as communicated in the reply, and the issue of defining the request for relief as liability as opposed to something else. I know we included that in our opposition. I agree with the court that that is a distinction that needs to be made. I feel that can be weaponized at trial if all of a sudden the parties are liable. So I appreciate the court's indulgence of that particular nuance, and I think we can move forward from there. Starting with the Kitchener order is actually kind of interesting for the opposition because of the fact that the law that's provided in the opposition to this particular motion, particularly at pages 18 and 19, starting with the Marlin Props case, which is 108 Nevada 946, clearly state that the Nevada Supreme Court has said that stipulations do not form a basis for entering a finding of issue preclusion.
So bear with me, because
I'll go there with you, Your Honor. Pages 18 of the opposition.
oh, okay. I was looking at her order and I was like, I don't think there's pages.
I sincerely hope there aren't 18 pages on that order. Your Honor.
Okay.
I'd be missing a few myself.
Real water so that you don't waste your time while I turn to it.
No, that's fine, Your Honor. I'm making sure that we put the citations on the record with the hope that the court will go back and take a quick look and verify that everything I'm saying is above board.
Sure.
So the point is, Marion Props and the other wealth of case law there stand for the proposition that a stipulation cannot serve as a basis for entering a judgment based on issue preclusion. In the reply, the plaintiffs provided a Ninth Circuit case that ostensibly says that, well, you can under certain circumstances, but that's not binding on this court like the other cases are. And Kitchener's order is problematic because Kitchener's order is effectively fruit from that poisonous tree, Your Honor. And I don't normally like to get up in front of the court and say, well, there's things on appeal, because we don't know what's going to happen in the Supreme Court and everybody thinks they've got the right of it, you know. But in this particular instance, if we go to paragraphs 31 and 32 on page 6, which is at Bates label 007, I would ask that the court take note of the underlying quote unquote factual basis for some of the conclusions that Judge Kitchener reached. And I'm quoting from paragraph 31. In the stipulation in order, the real water defendants admitted that they were responsible for and were involved with the manufacture, labeling, marketing, sale, and or distribution of the allegedly defective real water consumed by each plaintiff. And it goes on from there to talk about the jugs, contamination, unintentional contamination with hydrazine, and that the water is defective. She then goes on to state, and this is plaintiff's counsel drafting this order as an aside, that at the summary judgment hearing, and in light of the signed stipulation and order regarding real water's liability and causation, the scope of the motion was limited to summary judgment, that retail bottles were purchased and that they were unreasonably dangerous, and that these bottles were a substantial factor in causing harm. So this order is looking at those elements of the claim that plaintiffs have just said they will not be asking the court to rule on today. What this order is presuming is that the elements that the plaintiffs do want the court to rule on today were entered by stipulation. This is no different for the purpose of the analysis of an issue preclusion standard than any of the other stipulations in any other case, because this is the underlying set of facts that Judge Kitchener is relying upon. So if the court is inclined to look at Kitchener's order and say, this is the key document that helps me to make the determination about whether or not issue preclusion is appropriate as to real water, and I won't speak for Terribles, but I know they're in the same boat. Having an underlying stipulation recognized in the order as one, if not the only, primary factual basis for entering that finding makes it such that the court cannot rely upon the Kitchener order in entering issue preclusion. And even if the court reached other bases, opposing counsel makes arguments about how, for example, Terribles didn't meet their burden of proof once the plaintiffs have established theirs. The fact remains that that was, and I'm quoting from opposing counsel here, opposing counsel argued that Kitchener said, show me the evidence or basically be bound by the stipulation. Well, we're reverting back to the stipulation again as the underlying factual basis for that order. So if Kitchener's order is...
But didn't she say, hey, like you just said, show me either evidence, I mean, it doesn't that mean she's saying, hey, give me the evidence, if you don't want to be bound by the prior stipulation, show me the evidence that gets you out of, summary judgment, or am I not getting that correct?
I think you are getting that correct, Your Honor, and I think that's the problem. Under Marion, and even under the restatement second of judgments, which I believe both sides have cited as persuasive authority here, but primarily under binding case law, Judge Kishner's decision to rely upon a stipulation of another party or a prior stipulation of another party would mean that any order that's entered could not have preclusive effect under the guidance of issue preclusion
So
doctrine.
you and I might be on ships in the night. Because the way one, including me, may take what she said and did is she gave defendants Real Water and Terribles an opportunity. Okay, well, if you don't want to be bound by the stipulation, show me the evidence that shows that, plaintiffs presented a multitude of, testing, et cetera, testimony. Defendant, Real Water and Terribles, give me evidence that shows to the contrary. And I think you're still saying, well, that's for the poisonous tree, so to speak. And I'm not sure you and I are understanding each other.
I understand exactly what the court's point is. I'm trying to figure out the clearest way to kind of draw that line from my point of view. If we were to take Judge Kishner's position, then she did invite the parties to refute the stipulation. That's the court's point, that there was an opportunity to provide evidence that would refute her reliance upon the stipulation and entering that order. Is that what the court is saying?
No, I think that might be what you're saying. Because you're arguing, at least in part, Judge, Judge Hardy, can't rely on Judge Kishner's order because it is a result of or derives from stipulations. And what I'm saying is there is, it seems to me anyway, that Judge Kishner, okay, like even reading what you quoted, paragraph 32, yeah, I get where you're saying in light of the signed stipulation order, but then the scope of the motion for summary judgment was limited to summary judgment that one, the retail bottles purchased by Plaintiff Miles and Watson from Terrible Herbst in 2019 were defective and unreasonably dangerous. That, to me, seems like she gave an opportunity, said, okay, well, let's set aside the stipulations. Show me evidence, because I have a plethora of evidence from plaintiffs. You, Real Water and Terrible Herbst, give me evidence that shows they were not defective. And I think that's where you and I may be ships in the night, because to me that sounds like it was actually litigated rather than just stipulated.
So, Your Honor, unfortunately, and I'm not going to try and hide behind the fact that we were not counsel in this case, right? But I can't also opine on when I wasn't there. So what I have to rely upon is the black and white wording in the order. And when it says, in light of the signed stipulation, when the paragraph immediately preceding it specifically goes through the factual points that the court is accepting based on a stipulation between the parties, then I think, the parties can guess about what Judge Kishner may or may not have been inviting or asking people to fill evidentiary gaps, or maybe she was relying on other evidence that's referenced in the order. But at the end of the day, it's indisputable that the judge relied upon this stipulation. So everything else is, in my opinion, right, and my very unbiased opinion, of course, it's noise. Because at the end of the day, we have a very clear directive that says that this cannot be the basis for finding whatever we'll call what they're referencing as liability. And so that's really it. And Your Honor, I think there's a secondary point, if the court would allow me to move on just a little bit. The whole idea that the underlying issue, the opposing counsel brought up the manufacturing process. And I was anticipating doing this a little bit more in the other motion, but since we're here, I might as well dive right in. I had for the first time the chance to depose Dr. Najam, the chemist who opines on these two pathways. And he very clearly stated in deposition that he cannot plausibly tie his pathways, either or both together, to the amount of hydrazine that's in the FDA reports or the Eurofin testing. He can't do it. And so if we're really going to narrow down and focus on the quote unquote evidence that was presented in these prior cases, the fact is now we have testimony from their own expert that says, okay, well, Kishner's order references, as part of finding that it was a defective product, the fact that there was certain levels of hydrazine in these tests. And then plaintiffs want to take that information and expand it to say, well, because Dr. Najam has determined it comes from the titanium tubes, all real water across the board had to have had hydrazine. And because all water across the board had to have hydrazine, it doesn't matter who the plaintiffs are. Mutuality is no longer a problem because all of the water between the plaintiffs contained hydrazine. That's their theory and they're welcome to it, but Dr. Najam no longer supports that theory. If you can't tie the results of that testing to the product at the time of manufacturing, you've got a significant evidentiary gap. And I'm struggling to remember the word that Counselor Pepperman used when trying to say, well, it's not about the numbers, it's about the fact that there is hydrazine. Well, respectfully, Your Honor, especially at this stage, it's absolutely about the numbers. And so if we're really going to break down the manufacturing process, if we're really going to break down the idea of, okay, what is unreasonably dangerous when it comes to this bottled product? Now we're starting to get the fields of chemistry, and we're starting to get into the doctors who have to say, okay, what is a maximum contaminant threshold for hydrazine in bottled water? This is a relatively novel situation. There isn't really a number to be had. So what are the doctors saying is a sufficient amount of hydrazine to get somebody sick? Well, this is a motion for summary judgment. Those are trial issues. And so if we really want to call the product defective, the product has to meet the standard for something that would be unreasonably dangerous under Guinness. And that's not before the court today. Now, as Counselor Pepperman stated, you will have an opportunity to review the evidence, and you can review Guinness at that point and all of the relevant case law. I think Robinson, get my cases mixed up, Your Honor, I'm sure you are too, but point being, that's not before the court today. The court is going to have an opportunity at the next set of motions to make a ruling on the merits. And if the court wants to make a different ruling on the merits based on the evidence in this case, based on the expert testimony in this case, I think that would be more appropriate. But as far as issue preclusion goes, not only do you have a significant law issue with regards to the cases that we've provided at the onset of my argument today, but we have factual questions that have come up that need to be resolved. And that is important, Your Honor, because under Park Lane and the whole doctrine of non-mutual offensive collateral estoppel, I know it's academic, I don't intend on getting into that a great deal, but I think the U.S. Supreme Court made an excellent point. The Nevada Supreme Court has followed that this court has broad discretion to do what's right and to make sure that the parties get a fair trial on the merits. We have that motion coming up. We know that there are significant legal issues with granting this motion on issue preclusion based on the way it's been framed up in the moving papers. It'll create an unnecessary appellate issue, and if the plaintiffs really are that confident that the evidence that they have in this case will establish that there is a dangerous condition, they can present it, we can argue it, and this court can make a determination on the merits instead of trying to cycle back through some procedural offensive weapon based on Kishner, that was based on something that Judge Williams looked at, that was based on something this court looked at, that was based on something Judge Williams looked at. So, Your Honor, I'm trying to keep this as short as reasonably possible. I apologize for the extended argument, but if you have any questions, I'd be happy to answer them. Otherwise, I think that the moving papers put our position out there pretty substantially.
I think I asked you the questions.
Thank you, Your Honor. Pleasure.
Any rebuttal argument?
Oh, we have Nevada Beverage, I believe that's something.
Oh, sorry, go ahead, sorry.
Good morning, Your Honor. Colt Dodrill, different rider, different horse. counsel for Nevada Beverage. I want to talk briefly about how the issue preclusion applies to Nevada Beverage, get into our counter motion for summary judgment, reserve a little bit on rebuttal on that counter motion, keeping within the time, and I will be short. And I appreciate what Mr. Pepperman said about Nevada Beverage in respect to the issue preclusion argument there. However, Terrible Herbst is suing us, and we are also concerned about how that affects, or excuse me, how any judgment against Real Water or Terrible Herbst would affect us, even if Your Honor did not enter something against us. We cited Fro, which is a very old, long-standing law from the United States Supreme Court. It's been adopted by our Supreme Court in the Momasco case, and it rises in the context of a default judgment. And what they say is, well, when you've got joint and several on the hook, let's not enter a default judgment against one because it can unfairly affect the other, because there's joint and several liability, and there's a whole host of public policy issues. And one of those is the risk of a inconsistent judgment and inconsistent judgment. And we run that risk here. There's also the risk of, can Nevada Beverage get a fair trial when one of the co-defendants has been found liable as a matter of law by the judge? And in some of those cases, we run into an issue related to, but different than what we talked about before lunch, which is, do we need to try Nevada Beverage separately within the Hearst? Because that jury is going to hear, well, you've already found against Real Water, now let's talk about Nevada Beverage. Am I going to be precluded from raising some of these defenses at trial if one of my co-defendants has been foreclosed from doing that?
So, I mean, what would be the potential solution? Because let's say the summary judgment against, let's even go so far as to say summary judgment against Real Water on defect, and defect existed when it left Real Water's hands. I mean, are we supposed to allow, notwithstanding there may be no genuine issue of material fact on those 2 points, are we supposed to then allow Nevada Beverage to come in front of a jury and say, well, you know, the defect didn't exist at the time? I mean, it sounds like you're saying you get to litigate the whole thing regardless of whatever may be appropriate as to, you know, whether it's Real Water or someone else. Well, let's stick with Real Water because you're thinking between Real Water and Terrible. What am I not understanding there, I guess?
I think you're understanding it, you're just coming on the other side of it. One of the issues, and we briefed these two together because at least vis-a-vis Nevada Beverage, issue preclusion and claim preclusion, collateral estoppel have the same effect to us. They're both an estoppel. And so they handcuff us. We heard before lunch that we're trying to stop them from getting to trial. Now after lunch, they're trying to stop us from presenting a defense at trial. And it's kind of unique, but it's also not fair. So if you look at their briefs, they say that Real Water would not be able to present any argument. And we've argued those arguments have not been fully and fairly litigated, not by us, not really by anybody. The stipulations by Real Water in the early cases, and then the judgments against them in the subsequent trials, based on the earlier stipulations, have foreclosed an issue that is one of our primary defenses. In our opposition and counter motions, exhibits M, N, and O, we presented that very same evidence that apparently Judge Kishner, in a case we didn't argue, found lacking. The Eurofins tests are themselves severely limited. They only tested Real Water made in September 30th, 2020, and later. There's been no test of Real Water for hydrazine made prior to that date. And remember, the Shaparov plaintiffs, as you heard before lunch, are not suing us. Mr. Herbst's estate and heirs are. Mr. Herbst had cirrhosis of the liver. He was diagnosed with it 2016. The doctors don't know when he got it. You'll hear a little bit about that in a few seconds when we get to the fund causation part. So the question for your honor is when? When did Real Water have hydrazine? We know when it tested positive for hydrazine, but that doesn't mean it always had hydrazine. And you can, I use the DUI as an example. You can, I blow a .08 now. That doesn't tell you whether I was intoxicated 2 weeks ago, 2 months ago, 2 years ago. So that's really what happened with the Real Water and the hydrazine, and we're entitled to present that defense. There are genuine issues of material fact. Now, you'll see briefing in January that Mr. Pepperman referenced to, where you will find that they can't speculate that Real Water contained hydrazine prior to those test dates any more than you could speculate that a criminal defendant was intoxicated months before. There's a Loma Linda article, Exhibit N, and it's long. I'm only going to read one sentence that's in the middle of page, the bottom of the middle column. That's our exhibit on page 210, and they talk about 4 patients. And, you know, your honor should be concerned that you can't get a liver transplant in the state of Nevada. So the adults went to Los Angeles, and the children went to Utah. And there's 3 hospitals, and the 4 at the Loma Linda Hospital noticed the trend and reported it like they should. And that's the surveillance that our medical community do. And the author, Corey Burke, she's a nurse practitioner. We deposed her, very intelligent, very smart, a great witness. And she said, given the similar time frame of presentation in all 4 patients, this may be related to changes in the manufacturing process of Real Water during the fall of 2020, especially given that 2 patients had drank without any issue for years earlier. So people drank Real Water for years earlier, didn't get sick. Fall of 2020, folks get sick. So you've seen that, and you've tried some of those folks. That's evidence here, and the Nevada Supreme Court tells us in Wilson v. Circus, which adopted the landmark food poisoning case, Linder, out of California, that says evidence that some folks consumed the food without injury is at least circumstantial evidence that the food was not tainted. So there are issues here that were not tried. And I'm not going to repeat Dr. Najim's quote that Mr. Esposito cited. We referenced that in our brief as well. Dr. Najim doesn't know. I asked him, did it always contain hydrazine, this, that, the other, and we start talking about ammonia and pathways, and he said as long as ammonia went through the tubes. Well, spoiler alert, ammonia is not an ingredient of Real Water. That was an anomaly. That's our theory of the case. They think there was a bad batch where they added too much of the E2 concentrate. We think there was bad batches of E2 concentrate where hydrazine was made for the first time. And that's a full and fair defense. It's based on factual information in the record that's been obtained in discovery throughout this case. It's never been presented before a jury because of the makeup of the defendants and the counsel that were in those prior trials. That's fair game, and we want that to be alive. And you'll see several motions in limine probably from both sides on that in January. And I want to make sure that we're not foreclosed from presenting that argument. And if Your Honor is concerned over the risk of inconsistent judgments, we come back and talk about summary, and nobody wants to try the Herbst case twice. And I think it would behoove Your Honor to delay entry of any judgment against any defendant until the jury can make that decision, because that would unfairly prejudice us, and of course we want to avoid that at all costs. That's utmost Your Honor's role here in gatekeeping the justice. Moving to the counter motion, unless the court has questions on what we've addressed, I agree and slightly disagree with Mr. Pepperman's discussion of the elements of strict liability, and I know there's flexibility there, that there was a defect and that it existed at the time it left defendant's hands. I think I agree that's one element. Causation, whether it caused the injury, I break that up into two. We kind of skip a step there. The plaintiff had to have consumed or experienced that defect. In the case of the food, he would have had to have ingested it. In the case of, if you're going to talk hydrazine, he would have had to have been exposed to it, and then it had to cause. You can't jump to causation without saying he drank it, he put it in his hands. And so in this case, you'd have to put a bottle of real water that came from Nevada Beverage or Terrible Herbst in Milo's mouth. And I don't think they can do that. And so if before lunch we asked you to pull Milo Herbst out of the trial, now I'm asking you to pull the plug on the Herbst case because they can't make a prima facie case. And this is our counter motion. And you know Would Be Safeway, and you know Wiley v. Red, and you know all that fun stuff. And you also know Hallmark and Morsicato and of course Williams. And when we were here, and I argued before Your Honor on November 12th, and we were asking you to continue the case and pull us out, and we said we have not yet completed discovery. We're doing something like 82 expert depots in 17 minutes or something like that. And one of those was a depot of their keystone expert on November 19th, the last day of discovery, their medical causation expert. And this is a wrongful death case, Your Honor, I can't emphasize that enough. And I asked Dr. Kahn whether Milo Herbst would still be alive had he not consumed real water. And he said that he didn't know. Now he's the keystone expert, he's a medical causation expert. He has one job, and he failed miserably at it. And he can't testify as to causation. And you don't have to believe me, you can listen to the good doctor yourself. We've got him on the screen.
Would Milo still be here today if he didn't drink real water?
I don't know.
The case is over, Your Honor. We're done. There's no actual cause, and there's no medical cause. They have to show both. Under Wilson v. Circus, food poisoning case, he has to rule out other extrinsic causes. And he just told us he can't. He doesn't know. And so from a wrongful death case, you can't have liability without causation. They failed. They're done. And the case is over. I'd like to say it gets worse. I don't think it gets worse than summary judgment should enter against the Herbst plaintiffs. But it did, because they have the burden of proof. And they tried to switch the burden, and they tried to impose that burden on us. And you can't shift it. And I had the opportunity to depose Tevis Herbst, the lead plaintiff. She's administrator of the estate, very intelligent woman, a very good witness. And I had the opportunity to talk to her, and she doesn't know where Milo Herbst bought his watch. And again, we play that for him as well.
You said you saw him purchase real water at Spring Valley Market?
I don't know.
Did you ever see him purchase real water at Terrible Herbst?
I don't know.
Do you know who would know?
I guess Milo.
Well, we can't depose Milo, Your Honor. They're the plaintiffs, they have the burden of proof, and they don't know. She's not the only plaintiff. I got to depose her sister, Sarah, and she said the exact same thing.
Had you ever seen him purchase real water?
I've never witnessed him purchase real water.
Have you seen any documentation memorializing a purchase of real water?
No.
So there's no documentation, there's no receipts. You saw in the briefs, I asked them about the credit cards. They produced about 700 pages of credit card statements. That was mentioned earlier as part of the pending motion to compel, because it's all redacted except the Terrible's purchases, which apparently are for gasoline. And I asked them, do you have any reason to believe any of those purchases are for real water? And they said no. So there's nothing. So after that deposition, plaintiffs trotted out friends and other family members and business associates, and they all said the same thing. Milo said he drank real water. Milo said he drank real water. But that's hearsay. It's not a statement for purposes of medical diagnosis or treatment, because he wasn't telling that to doctors. It wasn't an excited utterance. He wasn't telling a police officer in order to report a crime. And they tell us in their briefs, hey, this falls under the catch-all provision. This does not fall under the catch-all provision, because there are no assurances of accuracy. And it's also not, and I'll go into those in a second. I want to mention that it's also not a dying declaration, because we know from deposing the plaintiffs, he was not contemplating death at that time. Can you play Sarah's, please? Don't.
But up until the doctor told him that he literally has 2 to 3 days to live, he thought he was gonna get better. He genuinely did not think he was gonna die.
That's not a dying declaration, Your Honor. He's not dying. And so they say, well, it falls under the catch-all because we can trust him. We can trust him. But we can't. These statements do not contain any assurances of accuracy. Put it up, Milo sent text messages, and he was in communications with Will Kemp. This is June of 2024, 5 months before he passed away. And he tells his friend, can you get my last blood work and fax it to Joe? He'll get it to Will Kemp's expert witness, a liver doctor from Washington, D.C. That doctor will talk directly to Dr. Redmond. Dr. Redmond is one of Milo's health providers, the one that would drain him in Cedar City as he was heading off to his ranch in Hatch, Utah. Milo is building a lawsuit, and the case law tells us that under those circumstances, someone has an incentive to fabricate. So it doesn't carry with it the assurances of accuracy that you would want in order to exclude a hearsay statement. Plaintiffs argue that Milo was confused. You saw that in the briefing when we talk about alcohol. Plaintiffs can't have it both ways. But what's worse is that Milo himself didn't know about real water. We're supposed to believe that he's telling people in 2024, hey everybody, I drank real water, I drank real water. But did he know? If you look at the text messages we put in, and they're up on the screen, Exhibit BB in our index. I just found out there's a company in Las Vegas called Pure Water. Now that's wrong for 2 reasons. Well, 3 reasons. He just found out. I thought he was drinking it this whole time, and now he just found out 3 years after the recall. That's not an assurance of accuracy. He just found out it's in Las Vegas. You look at the bottles, it says in 2 places it's made in Las Vegas. It says it's bottled by Affinity Lifestyles on the bottom, doing business as Real Water. Las Vegas, Nevada, provides the zip code. And at the top, it provides in the ingredients the source of the water, our Las Vegas Valley Water District. Somebody that drank as many real waters as they claim and left the empty bottles in cars and this and that and the other would know. And he would also know the name. The text message said Pure Water, but we know, we've said it 1 billion times today, Real Water. He doesn't know the name. He doesn't know where it's made. And he didn't know it was recalled. And we talked about that in the SOL briefing. And depending on how the court rules on this, if we need to go into the SOL motions later, we can. I think it's moot right now because I think Milo Herbst's case can't satisfy muster. I don't know doesn't pay the bills. I don't know doesn't get you past Williams. I don't know doesn't survive summary judgment. And I don't know how someone can march an expert to talk to a jury and say, I don't know. So Milo Herbst, Milo Herbst is gone. And the last piece, just to put the icing on the cake, he told Russell Riggs not only did he drink real water, but it was the only water he drank. But we know that's not true, because we obtained in discovery his Costco records. And we filtered it down, and we drilled down to just the store, 673 in Henderson, of course, which is the store closest to Milo's wine bar and apartment in Boulder City. And there's a ton there. We've highlighted, that's just the water. That's just the water. We'll zoom in on the next slide. We've highlighted just the half liters of Kirkland Select 16.9 ounce 40 pack for $2.97. Those are those. And then if Dylan can go back, Milo drank other water as well. He was a big fan of coconut water. He liked sparkling water. He bought LaCroix. He bought San Pellegrino. And he also found a Kirkland Select, which I think the court could take judicial notice. That's a Costco store brand. And what's glaringly absent from this is him buying any real water. It sort of begs the why a guy that goes to Costco every week or two and buys a ton of water never buys real water. We know Costco sold that real water. Miriam Brody, I believe other folks bought real water at that store, 673 in Henderson, of course. So I would ask that the court note this, and that they cannot establish actual cause. They cannot establish medical causation. Dr. Khan obviously can't testify. That's a separate motion in limine for January that I think should be moved based on your honor's ruling today. And I'm going to ask that you grant our counter motion and enter summary judgment in favor of Nevada Beverage and Terrible Herbst, and I guess real water too, and against the Herbst plaintiffs. Thank you very much.
Your Honor, just briefly for ET21, UBA Terrible Herbst. I join in Mr. Esposito and Mr. Dodrill's comments in court. Frequently, if Your Honor will recall, Plaintiffs' Counsel has referred to the Gallagher matter as the bellwether case. And indeed, it turned out to be somewhat of a bellwether case. And the only entity that ever tested retail bottles was a defendant in that case at one time, United Natural Foods West. They were in the Gallagher case. There were no retailers there. But the distributor for Whole Foods, United Natural Foods West, was a defendant. They settled out at some point prior to trial. So they, as you've, I think, gathered already, commissioned Eurofins to do some testing. But prior to the outbreak of the home office delivery product that was tested by the FDA at some point, and I think that time period was late 2020, might have been early 21, but I think it was late 2020. There have been no, as the court I think is now aware, there have been no other testing prior to 2020. By estimates, there were between 8 and 13 million bottles, retail bottles, sold since the late 2000s, approximately 2008, when I believe Real Water began manufacturing their product and distributing it, not just locally, but around the country. Amazon sold it, large retail chains sold it. With I think one exception in Ojai area or the coast above Santa Barbara, there's nobody outside of Clark County but one person in Reno who worked for Whole Foods that brought a lawsuit for the Real Water adulterated product liability cases. So you've got millions and millions of bottles sold all over the country. The only lawsuits, the only plaintiffs that we know that had injuries, serious injuries enough that they brought lawsuits are locally here. And the only time that test was ever done of any real water were those 2 times that we're aware of. Plaintiff never tested the product to try to prove it was adulterated. And they pieced together admirably a case from that. And the mistake of, if it was, of the 7 bottles, of which apparently 4 of the 7 bottles, retail bottles tested by Eurofins, came back with measurable amounts of hydrazine. In that bellwether case of Gallagher, which neither ETT1, Terrible Herbst, or Nevada Beverage were any part of. So by the time the second trial happens in Hunwartson, and it's natural for consistency of rulings, the judges are looking for what evidence occurred before and what they should base their rulings on. The fact that the retail defendant who wasn't in Gallagher, the Hunwartson defendant, my client, was not able to produce and prove the negative, I don't think that qualifies as litigation on the merits or sufficient to establish issue preclusion. I mean, I think the term is non-mutual claim preclusion. If plaintiff or another third party has a complaint, they don't bring somebody in, they run the risk that later somebody is going to try to sue them for indemnity, but they had an opportunity to bring them in, they didn't give that third party or that other defendant a chance to defend themselves. They run the risk of not being able to pursue that claim later. Well, none of that happened here, and the issue preclusion in Hunwartson, and now 5 trials later, it's raised its head here for us. There was no opportunity to actually litigate this on the merits beyond saying we have no proof to counter somebody else's ruling and stipulation in a prior, quote, bellwether case that we weren't a party to. And again, without going back over what Mr. Dodrill just capably pointed out, there's been a list of witnesses that plaintiff's counsel produced. Not one of them, not one, including his daughters, the plaintiffs, Travis Herbst and Sarah Colovi, not one of them have been able to testify to any degree that he purchased the product through Terribles. And not one of them had even knowledge of who else might have purchased it for him. We asked them also in these depositions, did they have any documentation that they might have gotten in the course of this litigation to show us where Milo purchased this product. Again, the fact sheets that plaintiff produced say he contracted his illness in 2016. That was more than 4 years prior to the first testing locally of product that was locally tested, and arguably medical toxicologists will argue about amounts and dosage and what kills Juliet didn't kill Romeo. Those kinds of issues are there, but nobody else got sick. Nobody else is claiming they were poisoned with hydrazine, but here. And so to have a plaintiff like Mr. Herbst, who's completely shown to have had the liver disease that ultimately killed him 4 years before any testing was ever happened, or that it's, there's no medical causation, there's no actual proof he ever got the product from our client or from our distributor. Again, the bellwether case is what it is. And ever since, folks in these cases been trying to argue, I think, not just on fairness, but on actual no opportunity to really dispute something that, you know, they can't prove a negative for, that they didn't stipulate to begin with. We did not, we do not now. And there's overwhelming, I think, evidence to the contrary, that there is no liability, there can be no liability, because there's no causation that Mr. Herbst ever consumed or was harmed by our product.
So, you know, I asked the co-defendant's counsel's, you know, reading Judge Kishner's order, it certainly seems to me that she decided that issue on its merits. Is your position similar to his, that, you know, it's quote unquote, let's use another word than poison, maybe affected by, relies on the stipulation rather than giving an opportunity to both Real-Water and your client to say, hey, plaintiffs have given me all this evidence showing that the product's effective. Where's your evidence? And if you didn't, you know, plaintiff met its burden, you didn't have any, that seems like it would have been on the merits. But are you saying similar to your colleague, hey, yeah, we did give evidence, she was just wrong, or what's your argument on that?
Well, there's two parts, I would say. Again, I'm not hiding behind not being the counsel for my client at that point in time, at all. But I will say that I'm not sure where in the time period these things happened, but there were some mistakes that were determined to have been made that resulted in evidentiary sanctions against my client. Ultimately ended up pretty much handcuffing its defense to anything but punitive damages through the course of findings by the court of a failure in the discovery issue, serious discovery issue. And I honestly can't tell the court, I know how those events and those determinations by the court and what turned out to be a pretty strong pair of handcuffs on the further defense by my client of the claims at that time overlapped. If it were a Venn diagram, how that would line up. But I am saying what I'm saying, that no one that represented our client ever stipulated voluntarily, apart from any kind of, you know, in this bellwether case where this is all fruit of that particular stipulation. And none of us were involved in that, none of our clients were involved at that time. And I can't speak for why the judge's rulings came out the way they did, but I'm here now to tell Your Honor that this is a case where there is just no proof that the product was consumed by Mr. Herbst, let alone that it was consumed by Mr. Herbst's product he got from my client or my client's distributor. And these issues, we tend to break them down, and we're here, as I would if I were across the table. I'd be boxing folks in with these very strategic motions, but the issues are too intertwined for that. This kind of motion is built on, I think, a false premise to begin with, that there's not a dispute, there's not genuine material facts disputed about any of these statements. It's just clear by the nature of how these things have come together. There's evidence that there's no consumption proof to begin with, let alone how can the court rule on, we're just asking you to rule on liability, not on causation. I mean, it doesn't make sense to me, because when I look up the dictionary definition of liability in a products liability case, it's clearly going to include causation, actual and specific.
So are you saying that products liability doesn't have elements?
No.
And what are you saying? Because I don't follow what I think you're saying, well, you know, all the elements are lumped together, it's your product liability, but maybe I'm misunderstanding.
There's an assumption implicit in this motion for partial judgment of defect. A defect that was stipulated to in the bellwether case. The stipulation was it's defective product and it injured the plaintiffs. And the only question will be, what were the damages from this horrible event? And that's how they went to trial, based on the stipulations. And I'm trying to inform the court, there's no proof that my client sold a defective product. I mean, there's no proof he sold the product to this plaintiff, but there's no proof it was defective. Remember, their fact sheet said he was sick in 2016. The earliest test anybody did, and there were only a couple, and they were by the plaintiff, was 2020. And that wasn't even the retail product then. So how can the court reach a decision of defect and therefore liability? What was it that was deep? What product that they can't prove we ever sold to this plaintiff, but what product sold in Boulder City or anywhere by Terrible Herbst was defective? Again, 8 to 12 million bottles sold all around the country for many years. And only a piece of time that people get sick. And only locally, generally speaking, here. Instead of all over the country where it was sold. And the only tests that were used as a basis to come to this decision of defect and liability stipulated to were tests that happened years after this poor gentleman was deathly ill already from liver cirrhosis. 4 years before they ever tested it, he was already dead man walking maybe at that point. And there's tons of medical records. Well, we don't have them all. We wish we had more. But we have enough to know he was dead on cirrhotic in 2016. 4 years before the first test of the home office delivery product. 5 years before the testing of the Eurofins retail bottles, which was only partially successful to find the product had adulterant in it. And then there's the whole disputes of the half-lives and the degradations and all those issues. But to come now and ask for and to say there's no genuine issue of material fact, that's not true. There's a lot of genuine issues of material fact that the product was defective that we were selling. And number one, there's no proof this plaintiff bought it from us. Again, 12 to 4, depending on the estimate, Your Honor, it's not really disputed or definitive, but it's in the many millions, estimated between 8 and 12 million around the country. Why is it necessarily my client's store in Boulder City or Henderson or Arizona? How can we say that we had a bad batch or that, you know, but as counsel pointed out, it's their job, it's plaintiff's job to come forward with a proof the prima facie case, and again, the discovery issues we touched on before. We are not, we don't have evidence we've asked for to show that. So I appreciate your hearing me out, Your Honor, but that would be, if you have another question, I'm happy to try.
Thank you. Any questions?
All right, that was a lot. I'm going to start with the motion for partial summary judgment based on the doctrine of issue preclusion. So, I did my best to try to keep the issue narrow and focused, and I think defendants did their best to try to, make it a big can of snakes jumping out. I want to try to bring it back and just reiterate the rule of issue preclusion. Quote, if an issue of fact or law was actually litigated and determined by a valid and final judgment, the determination is conclusive in a subsequent action against the same parties. That is LaForge v. State University and Community College System of Nevada, 116 Nevada 415. That is the rule, and the reason for the rule is important public policy objectives, including preserving the integrity of the courts, fostering finality, and minimizing the potential for conflicting judgment, which promotes confidence in the judicial process, advancing judicial economy, and, quote, avoiding the substantial time and expense associated with repetitive litigation. That is the point of this doctrine. That is what the well-settled doctrine is designed to prevent. Defendants in one case from getting up and saying, okay, we acknowledge that there's hydrazine in the product, it's in all the product, we admit it's in all the water, it was formed during the electrolysis, we agree with the experts, we don't need to retain our own experts, they're right, this is how it was done, and then, oh, we don't like how that turned out, so let's go back up and say, never mind, these experts are wrong, and totally reverse and try to repeat litigation to get a different outcome. That is exactly what is precluded under the doctrine. It's the exact reason for it. And when you look at the rule, we have a issue of fact that was determined, the defectiveness of real water. It was litigated with evidence. There's a public health investigation, FDA testing, significant hydrazine found in every single sample of the concentration for which it was tested. We have an FDA determination and report saying all of real water is considered adulterated because the concentrate is a common component of all the water. It's a common ingredient. We have testing on the urethane bottles proving the obvious that when you have hydrazine in the concentrate and you put it in, use the concentrate to make the water, you're having hydrazine in the finished product. We have the proof of that. That is proof of a defect. That is a defective product. That is exactly the evidence, along with the expert evidence, unrebutted about how that hydrazine got in there, and the binding 30v6 testimony about how it was always the same process all the time. And that doesn't even bring up the significant other evidence, such as the numerous complaints going back years where they're, getting complaints of chemicals in the water, oily substances in the water,
Smells.
fishy smells. Your Honor, experts testified. This ammonia that was contributing to the production of the hydrazine in the electrolysis process, that it has a fishy smell or a chemical smell. I mean, the fact that real water is getting these complaints and not testing it or sending the water out for this broad-based generic GCMS testing, which would have identified the hydrazine in there, even if they didn't know what it was, the fact that they didn't do that, that's not evidence that there wasn't hydrazine in the product. That doesn't rebut the mountain of evidence that we've put forth in front of Judge Kishner when she reviewed it and said, okay, this is substantial evidence. Plaintiffs have met their burden of proof. Defendants, if you want to avoid summary judgment on this, show me your evidence. And they didn't. They had none. The issue was actually litigated. It was determined by a valid and final judgment, separate and apart from all the stipulations after that and further judgments. That determination is conclusive in this action against the same parties. And Nevada Beverage, when they stand up here, I said the same thing before, but really the rule is a party or they're privy. Nevada Beverage is a distributor of the product. They have a distribution agreement with Real Water. They are in privity over their interest in this product. It's manufactured, distributed, and sold. They're all in privity together. So the fact that Nevada Beverage had settled out before Judge Kishner's summary judgment ruling, it really is inconsequential. They're still in privity. It was the same evidence. They're still in lockstep with Real Water and Terrible Herbst in the chain of distribution, and the summary judgment should apply to all the defendants based on the clear doctrine of issue preclusion. Your Honor has not heard a single reason not to apply issue preclusion in this case to relitigate this issue. You see no evidence. I mean, there's nothing. I mean, they're just standing up here saying, don't do it, don't do it. It's unfair, it's unfair. But that's not what the law says. That's not the standard. Of course, that anything that doesn't benefit them is unfair. But that has no pertinence or relevance to the application of a very clear doctrine. And if it doesn't apply here, where does it apply, Your Honor? Honestly. So with that, Your Honor, we would ask that partial summary judgment on the issue of liability, defect, and that it was defective when it left each of the defendant's hands be entered, and so that we could resolve that issue, save both the court and the parties substantial time in not having to relitigate issues that have long been litigated and decided fully and fairly, and focus on the matters in dispute, which are largely damages and this certain causation issues with respect to Milo Hearst. And unless Your Honor has anything else or wants to pause me before I move on.
Go ahead and address now their counter motion in terms of, essentially their argument is there is no genuine, I mean, they say no evidence, but really no genuine issue of material fact. The plaintiff hasn't demonstrated that Mr. Hearst at any point in time ever drank real water and or bought real water from terrorists.
Yes, Your Honor, and so I want to again start with the standard on summary judgment. I know the court is familiar with it, but I think it helps, kind of frame these things that, they're basically saying is we're the defendants, we don't have the burden of proof, you have no evidence of of causation. You have no evidence that he consumed it, and you don't have any evidence of medical causation. So on summary judgment, our job is to show you evidence from which, when interpreted in the light most favorable to the non-moving party, demonstrates a genuine issue of material fact for trial. And so I want to start with the evidence of consumption. Shane, can you pull up the opposition to counter motion, page 3? Now, Your Honor, what they come up here and say, and
Just pause, because
oh, do we need to?
what are you looking at? Is this your brief or theirs?
This is our brief, our opposition. Turning to page 3. Now, when they come up here and their argument to you, Your Honor, is there's no evidence that he ever drank real water. They haven't shown anything. Well, that is just simply not true. And we'll start with eyewitness testimony. Okay? John Colovi's the first witness listed. He is Milo's son-in-law, and he testified. And he testified to his personal knowledge. He personally observed Milo Herbst drinking real water, and he describes it. They had dinner at Nora's. They drove to his property at Blue Diamond. He was drinking a bottle of real water. He personally observed Milo Herbst drinking real water.
Yeah, I remember now that you're jogging my memory. Just as an aside, I guess, but I mean, any time I heard real water before, I had the same kind of reaction that he did.
Exactly, Your Honor. And this evidence is consistent with the evidence we've seen across all the other cases of consumption. This has been a constant theme, because we're talking about people who have suffered injuries from bottled water years after the fact. It is not routine to have, a detailed memory of instances where you've purchased water or were with someone when they purchased water. But real water has a unique color, a unique bottle, some unique labeling, it has a unique name. And so it's very common that people do have some recollection of it because of these conversations, and that's exactly what he's testifying to. His personal knowledge. This isn't hearsay, Your Honor. This is a witness testimony, sworn testimony that is evidence alone that he consumed real water. Then the next we get to Mr. Lucas, who was Milo's neighbor at Hatch. Mr. Lucas was not deposed, but we attached a declaration from him to the opposition. Shane, do you have the exhibits? If you could pull up, I think it's Exhibit 4, the Lucas declaration. I brought my glasses. Okay, Shane, we're good. We can leave it in the brief. We included the 2 key parts. So
it's Exhibit 2.
Oh, I'm sorry. Yeah, this is fine though. The 2 key paragraphs from the declaration, he explains how he knew Milo. They were neighbors in Hatch, Utah for 15 years. And since the first time he met him, he regularly observed Milo drinking real water. I recall the blue-colored water bottles such as that attached here too, and I remember observing cases of water at Milo's house in Hatch.
Of the water, to be more specific.
The water, and there's a picture attached where he's saying, this is the water I observed.
Go to then, their other argument is there's no evidence that Milo purchased from Terrible.
So With respect to his purchases from Terrible's and purchases of real water generally, Milo Herbst was an entrepreneur. He was a real estate owner and leased premises, and he owned a property. The state still owns it. It's on Flamingo and Wendell approximately. And it's a multi-tenant building, and there's a convenience store in the location. For many years, Mr. Herbst kept a residence in the building. Oh, I'm sorry, thank you. Page 16 of the, if you could pull up page 16 of the opposition, Shane. This is a picture of the property. And so at this point in time, in this picture, the property is a Spring Valley market. And prior to the Spring Valley market, it was a Terrible Herbst. And if you see to the right, you can see the other units. There's a laundromat there, some other businesses. And Milo kept an office, a real estate brokerage office where he worked out of for many years. And he kept a residence where he stayed at times and lived at primarily for several years. And the testimony, both stores, Terrible Herbst when it was there, and then later Spring Valley Market, both stores sold real water. Both stores were distributed real water by Nevada Beverage. And Milo would regularly shop at the convenience store and bring the cases of water up from his store to his office and or his residence when he had it there. You were shown some testimony about Tevis Herbst, Milo's daughter, and you were shown a little snippet. What you weren't shown is when she was talking about how it was Milo's pattern and practice to regularly shop at the stores, and then he would regularly purchase water. He was a water drinker. He would regularly get his water down there. He would regularly take it up there. That she was with him on many occasions, but she could not recall specifically that it was real water that he was buying to take up there. So when they're asking her, oh, you never saw him purchase the water, she doesn't have a specific recollection of it, but she testified to his habit and his routine. And after Milo learned of the connection between real water and his liver injury, and you may recall this from all the arguments on the statute of limitations issue, he learned of the connection between real water and hydrazine and liver injuries. He believed he had drank the water. He had told his several people, and his daughter included, that he had drank the water, that he had purchased it from Terrible Herbst regularly downstairs when Terrible Herbst was the tenant, and that they needed to talk to his doctors about this because this was the cause of his liver injury. He put it together. And so as part of that process, he was repeatedly telling his daughter, who was his advocate and caretaker at this point in his life, and in terms of his medical care, to provide this information to his doctors to review. There's the so in addition to Tevis, Mr. Herbst was with other people who were accompanying him to his medical appointments. And starting on page 16, we can look at Russell Riggs, another neighbor in Hatch. Mr. Riggs was a 30-year law enforcement veteran. Mr. Riggs testified that Milo confirmed to him that the real water bottles from the convenience store, the real water bottles that he got were from the convenience store that he leased in his building downstairs to Terrible Herbst. And the testimony starts on page 16. Did you discuss where he got the bottled water from? Answer, I think the only discussion I had is that he told me that he had purchased real water from, I think he said something about that he had rented a place or he leased a place above a distributor of real water, and he had been drinking real water for a long time. And he thought that was probably the reason for his illness. So he said he leased a space to a real water distributor. Is that correct? Answer, yes. That's as I recall, yes. If we can go to the next page, Shane, 17. Second paragraph with Ronald Murphy. Ronald Murphy was another close friend of Milo Herbst, and he was a business partner in a billboard company, and known him since 2012, and were close. Mr. Murphy also testified that Milo confirmed to him that he purchased real water from the Terrible Herbst convenience store below his office. When asked, did you discuss real water with him at the time in June 2024? He said, we did, yes. What did he say about real water? He said that in light of the article, he was quite agitated and irritated, that he said this is the only water that I had drank for quite some time. He had said that he got it from the store below the offices. Again, he confirmed, but he said he got it at the store downstairs by his office. Yes. Asked again where he got it from. He told me he had access to it from the store downstairs and he kept stocked with it. Stocked in his office? Correct. So again, part of his pattern and practice, he's going downstairs to Terrible Herbst, he's getting cases of water and he's bringing them upstairs with him to his office. That is the testimony and the evidence. He believed that it was real water that caused his liver injuries. We have the picture of him. When he found the article, he had a conversation with another friend, Riley Miller, who also observed him with real water bottles.
So, just cutting a little to the chase, I mean, I don't think there's any way I can grant summary judgment on the alleged fact that he never drank real water. I mean, that's certainly, not a thing to issue summary judgment in favor of the defendant on that alleged fact. One of the arguments that one of your friends on the other side, to use some nomenclature there, made was, hearsay. Which, generally speaking, when people say it's hearsay in general, it's almost not hearsay. This may be the exception to that rule when you're talking about these people who say, Milo told me that he got it from the store. Address that if you could.
Yes, Your Honor, I was going there, but right before I did so, I wanted to show one other piece of important evidence that I think is important and it bears on that issue. Shane, if you could go to page 7 of the opposition, please. So this is the testimony of another close friend and handyman for Milo Herbst who testified. And if you recall, the connection that Milo drew between his injuries and real water had to do with the
RJR.
Yes. So prior to the Review Journal print article being published, there was an article online the day after the verdict, which is what Milo originally saw. And after seeing that, he had a conversation with Riley about the water and told him, hey, I just found out about this water that I think made me sick, and he basically warned him about it and said, be careful of the water that you drink. And based on that conversation, Riley was out the next day and saw front page of the print Review Journal, the printed article, and said, oh, this is exactly what Milo was just telling me about, and he bought a copy and he brought it to Milo's house and he left it with Milo and left it on his countertop. And he texted him, I left the newspaper on your kitchen counter, there's an article you might be interested in. And if you go to page 8, this is a picture of the article.
This is the one with the handwriting.
This is the handwriting, yes, Your Honor. Now, this article shows Milo's notes. It's a photo taken by another witness who was deposed, Mr. Murphy. And Mr. Murphy described that he was traveling from Pahrump to Hatch, Utah on June 21st, 2024 to spend time with Milo in Overton and to pick up a trailer or something they were working on. On this trip, Milo showed Mr. Murphy the June 18th RJ article that Riley had purchased for him and showed him the story and explained to him, hey, this is the water I was drinking. I got it from Terrible Herbst, the store I leased. I think this caused my injury. And he wrote on there, show to Dr. Redmond, who was Milo's treating hepatologist, his doctor, and had notes regarding having Dr. Redmond review it. So this is important because this is someone saying, hey, this is something I think I was exposed to, and I'm having these liver problems, and I'm stating my intent to show it to my doctor. Mr. Murphy took the picture of it, he authenticated it, he said, you know, I was interested, I wanted to read it at some point. He took a picture of the cover page and the inside article to read later. And then he recounted the conversation about Milo taking it to his doctor and intending to take it to his doctor for medical purposes. He wasn't taking it to his doctor for lawsuit purposes. He was taking it to his doctor for medical purposes. That's the testimony. If you go to page 10, Shane, please. This is another picture of Mr. Murphy and his wife and Milo Herbst on this same trip. Mr. Murphy testified he was a big picture taker, so that's why there's a lot of photographic evidence of this. And then if you go to page 11, Mr. Murphy also snapped a picture of Milo walking into the medical center with the newspaper in hand. Mr. Murphy authenticated the picture. We had it blown up so you could see very clearly the Review Journal article in Mr. Herbst's hand as he's taking it to his medical provider. Mr. Murphy further confirmed that he was there and he observed Milo taking this article to his doctor. And that was the intent. Okay. So the argument is that, well, you know, these statements from Milo saying that he drank the water, he got it from Terrible Herbst, he drank it for years, that's all hearsay. And Your Honor, I think correctly, draws a distinction between certain evidence as not implicating hearsay at all. So there's no issue there with some of this evidence. Certainly, in terms of other evidence, it is not hearsay. A picture of him carrying the newspaper in is not assertion offered for the truth of the matter asserted.
But like that one, I mean, that goes to my point in terms of, I don't know. Well, choosing my words more carefully here, I don't see me granting summary judgment on any alleged fact that he ever drank real water. I mean, that's contradicted by the record. The main issue, I think, for you is this terrible, where he got it from.
Yes, Your Honor, I understand that, and I was just pointing that out because it's the first exception that we look at is the general exception, which the emphasis is corroborating evidence. And so it is extraordinarily significant that we have substantial corroborating evidence that is not even, there's not even a question that it's hearsay, because that is important and relevant to consider when you're looking at first the general exception, which I think is broadly applicable here. So the general exception is 51.075. It states a statement is not excluded by the hearsay rule if its nature and the special circumstances under which it was made offer assurances of accuracy, not likely to be enhanced by calling the declarant as a witness, even though the declarant is unavailable. And if we look at page 19 of the opposition, we cite the Johnson v. State case, which notes that corroborating evidence is a key factor. And it looks at, when you have the corroborating evidence, what's the reasonable likelihood that it's going to be different if Milo were here to testify? And so that's why the corroborating evidence is so significant, because it is substantial. First, we have Terrible Herbst, who substantiated the statements. Or her statements, what Milo telling her, were substantiated by numerous other witnesses. He said the same thing to Terrible Herbst, to Sarah Colobi, to Riley Miller, to Ron Murphy. They all testified to the same thing. It's all related to the newspaper article that he is showing exists, taking to his doctor, which is corroborating evidence that what he was saying was accurate. And those types of special circumstances, how often do you have someone, a picture of someone walking into a doctor's office with the material that they're talking about, and that's the source of the conversation? So, I mean, these are all very strong corroborating circumstances that he's not just making this up, and that there would be any significant difference in here if we were able to ask him the same questions today. And so that is the key factor on this exception. And as we state in the brief, the evidence corroborates itself, the witnesses corroborate each other, there's contemporaneous pictures with the newspaper article, there's contemporaneous notes, show to his doctor, he takes the the picture of him taking the article to his So you have circumstances built on circumstances built on circumstances that all validate each other and verify each other and are all consistent and all accurate. Then this is also corroborated by the circumstantial evidence regarding his habit and routine, which is not inadmissible hearsay, that he regularly got water and brought it upstairs. And that's exactly what the witnesses were testifying to from years later. So you have all the testimony corroborating itself, that, you know, just in and of itself. Then you have another hearsay exception, multiple, and I want to get to those, but I don't want to
Tell me about your best one.
forget to say that this evidence also corroborates this other evidence, these other statements. So you have statements for medical diagnosis or treatment. That is NRS 51-115. The picture and video of Milo Herbst walking into the hospital with the real water article demonstrates in and of themselves that this was for medical treatment. Mr. Murphy testified that he was seeking it for medical treatment. He was, the notes that showed to Dr. Rudman, no dispute, that's his treating hepatologist. So these are all things that are for the purposes of medical treatment, that relate to the medical treatment, his information that he had consumed this product that contained hydrazine. He learned of it, and he's telling his doctors this. He's planning to tell his doctors this. So these, as I mentioned before, his daughter Tevis Herbst at this point in his life was a caregiver, and so he was telling her information for the purposes of the medical diagnosis. That text that you were shown on the screen, I would note that that was a text to Tevis Herbst to say, hey, get my blood work so that this expert can contact Dr. Redman, not file a lawsuit, Your Honor. And for the record, we did not represent the Herbst family at the time. We never heard from Tevis Herbst. The first time that we ever met her was after Milo's death. So none of this is for some scheme to file a lawsuit. He's seeking information to provide for medical diagnosis or treatment. That's a very clear hearsay exception under NRS 51.115. The next hearsay exception is the dying declarations.
I don't think that one applies. You can
Well,
try
Your Honor,
to argue me out of that one.
so there are two, yeah. So starting on page 21, just so we have a clear understanding of the rule, of dying declaration is an exception if the statement was made by the declarant under belief of imminent death, so long as the declarant is unavailable as a witness. Okay? So there are two kind of time periods. One is in the several months leading up to his ultimate death in November 2024. Certainly, we cite the medical provider's testimony that said that he was terminal and was going to die. That is evidence of imminent death for the purposes of applying this declaration. So you have that time period based on the diagnosis of the medical physicians. But then you have a second time period where he was admitted into hospice. So there could be no question that when he's admitted into hospice, his death is imminent. I mean, That's what hospice means. Even their argument about, with Sarah Colovi's testimony, that he was, scared, basically. And she interpreted him as thinking he was not gonna die. Even that wasn't even a question in dispute when he went into the hospice. He was, as Mr. Cavanaugh so crudely put it, a dead man walking at that point. So there are numerous statements in the hospice to both Tevis Herbst, Sarah Colovi, and I believe Ron Murphy. And that testimony is what we looked at already, and it's basically the same thing. I drank this water, I got it from Terrible Herbst. Those are subject to the dying declarations, hearsay exception. They were stated in hospice. I mean, they're corroborated by other evidence, and they're admissible and corroborate the other statements to the other witnesses. Then,
You've got 5 minutes.
two more things, Your Honor. I just want to bring up two more things. One other hearsay exception is the then existing mental, emotional, or physical condition, NRS 51.105. And that's a statement of an intent, plan, motive, design. And clearly, he was making these statements intending to bring information to his medical doctors, get information to medical doctors. Those are another exception to the hearsay. And then finally, this evidence of consumption and purchase was relied upon by the plaintiff's medical causation expert, Dr. Kahn. And, even if you were to find for some reason that, some of these statements are hearsay, which I think they're all accepted, but even if they weren't, certainly this type of information is the type of information that is relied upon by experts to form their opinions. And so that they can rely on it, they can use it and base their opinions on it. And so summary judgment is not appropriate on these grounds. And Your Honor, I would just, Mr. Kemp reminds me that Nevada Beverage was the exclusive distributor of retail bottles of real water in Las Vegas. So the issues of Terrible Herbst don't apply to Nevada Beverage because the evidence of the water that he was drinking was distributed by Nevada Beverage as the exclusive supplier. So that is evidence undoubtedly with respect to Nevada Beverage. Yeah, Costco was not, Nevada Beverage did not distribute to Costco, but they themselves proved that the real water wasn't purchased from Costco. And by the way, on those records, Your Honor, those were business records from Milo Herbst businesses. But either way, not here nor there. I know I have a very short time. I just want to make one last important point, Your Honor, which is related to the medical causation argument, Dr. Kahn. So this is the problem with, filing the premature counter motion for causation, because Dr. Kahn was deposed on the 19th, was the same day we filed the opposition. And so in their reply, they come in and they're allowed to just kind of cherry pick and take out of context and misrepresent Dr. Kahn's deposition testimony. So I do think it's important to make sure that we're clear on Dr. Kahn and that argument. Number one, their argument about medical causation is completely made up based on the Wilson v. Circus case. This standard that we have to rule out every other possible cause is not the standard. The standard is the substantial factor test. And we've established that in the brief. It's a substantial factor causation. It's a legal cause. There's really no way around that. And as we cite in the opposition, Dr. Kahn's declaration in support, he says it is his opinion to a reasonable degree of medical probability that hydrazine in real water was a substantial factor in causing Milo-Herbst cirrhosis and ultimate death. He testified to that during his deposition. Shane, do you have his deposition, just a transcript?
I do, which page?
We'll pull up page 218. Lines 12 through 16. So his testimony, starting on line 14, hydrazine from real water was a major contributor to his cirrhosis or his progression of cirrhosis.
Yeah, so that's enough on that.
Okay.
I mean, sometimes, well, anyway, I'll just find out. 20 minutes rather than just 10 or whatever more they had. Let's take a break though, man. Come back at the 3:25 and we'll have 20 minutes on defense side and then we'll be done for the day.
Come back at 4:30, 4:30?
Sorry. 4, yeah.
I was trying to turn the clock back.
Yeah.
Well, it did. Thank you, Your Honor.
Oh, sure, of course. Yeah, let's wait.
Let's do this, Mr. Pepperman, you're. And Your Honor, while we got a moment, we did not attach the video depositions of these witnesses, the corroborating witnesses. If the court is going to assess the credibility of them, we would like at least to tender that to Mr. Williams.
So I'm not assessing credibility video.
Okay, well, I mean, just with regard to the general exception, that is part of the application option. So if you do want it, we do have that. It's about 50 minutes long.
20 minutes. By whomever.
I can do it, Your Honor. Colt Dodrill, counsel for Nevada Beverage. Thank you. I know it's been a long day. I want to get you out of here. I want to first address Dr. Kahn. The legal standard in Nevada is to prove actual cause and legal cause. And Dr. Kahn was unable to establish actual cause. If Milo's going to die anyway, if Milo's going to get cirrhosis anyway, there's no but-for causation. There's no actual cause. The case is over. I'm going to cite with the Safeway, the non-moving party has the obligation to bring forth admissible evidence to show a genuine issue of material fact. It has to be all three. It is not material whether Dr. Kahn stated that real water that Milo may or may not have drank was a substantial factor. if there's no but-for causation. You need both. They've only got at best one. I argued earlier that they didn't have either. The court seems to think maybe they skate by on legal causation, but there is zero of anything as to actual causation. So Dr. Khan is still not sufficient under would-be Safeway, and so that's immaterial. We all know hearsay is an out-of-court statement offered for the truth of the matter asserted. The truth being what? That he drank real water? Well, I didn't hear anything about anybody that, on the Terrible Herbst, and that's huge. And the hearsay exception, Your Honor is correct, it's not a dying declaration, you can't look at it retroactively if he ends up in hospice 5 months later. It's not a statement of medical treatment. He was, they're saying at the same time he needed treatment, but he was done. So they can't have it both ways. The fact that he later ended up in hospice is immaterial under would-be Safeway. This is a hearsay issue, evidentiary issue, part of the judge's gatekeeping function. The newspaper is nothing. You videotape somebody walking in carrying a newspaper is insane. And as an example, I have a review journal right here. It says on top, written in pink, show to Judge Hardy. You're Judge Hardy, and I'm showing this to you, and this means absolutely nothing. This is yesterday's review journal, and it talks about Governor Lombardo, and this does not tell you anything as to whether I voted or whether I knew Mr. Sisolak was no longer the governor. The newspaper is neither admissible, genuine, or material, and the catch-all hearsay exception makes absolutely no sense. They talk about corroboration. Tevis filed this lawsuit with the hopes of becoming a billionaire. Sarah Colobi filed this lawsuit in the hopes of becoming a billionaire. Her husband, John, who may have seen him drink real water once in a car in 2018, stands to be married to a billionaire, or hopes to be married to a billionaire. I don't think they stand anything as the point of me being up here today. The John Colobi saying, I saw him drink real water once when we were coming back from a fancy dinner. Didn't mention Terrible Herbst, didn't mention where he got real water from. So that is neither genuine nor material. The purchase, Terrible Herbst, that doesn't mean anything, Your Honor. There's a sushi restaurant across the street from the entrance to my subdivision. That is not evidence that I've ever eaten a California roll. That is what we call, in would-be Safeway land, immaterial. That doesn't fly. That doesn't do anything. Dr. Khan's sham affidavit fails under Aldave versus Adams. You can't change your testimony. You can't change what's going on. Something about defeating a lie from the mouth of whatever. The evidence that plaintiffs purported to present to Your Honor would have to hit the gym twice a day and have 3 protein shakes in order to bulk up to become gossamer threads of whimsy and speculation. It is less than smoke and mirrors. The fact that 5, 6, 7, 8 people are all repeating the same thing because they either hope to gain and become millionaires or hope their friends become millionaires or billionaires is not corroboration. It's at best collusion, and I remind the court of the purpose behind the hearsay rule, which is to avoid things like this. I can't impeach the dead. I can't cross-examine Milo. We're just supposed to take their word for it and go to the jury. That's not how it works. That's not how any of this works. There's no evidence he bought it at Terrible Herbst. And the last minute Hail Mary that, well, Real Water's exclusive distributor was Nevada Beverage, except for Costco, but except for Whole Foods too, except for Sprouts, and before 2012, but we don't know when Milo drank it before 2012. It was distributed to Terrible Herbst by a company called Cormark. That's neither here nor there, nor in their papers. It's nothing. And I remind the court, the would-be Safeway finally adopting Celotex and all those fun cases, admissible. The other thing that's not admissible is speculation. They can't speculate where he bought it. They can't speculate when he bought it. They have no idea. The handyman that was at his house 1,000 times and saw a half-empty bottle one time, that's not genuine. All these folks know that Milo Herbst. Oh, I need the medical records so I can get the blood work to Mr. Kemp's expert. That is literally the epitome of an incentive to fabricate. This whole thing. They knew it. They had this whole thing on a lawsuit, and they're going to say that. Well, how do you know? Well, Mr. Kemp is a very fine plaintiff's lawyer, and that's his job. That's his one job, and he's very good at it. And when he's involved, you know there's going to be a lawsuit. You know it's probably going to be a really big one. And everything is happening in 2024. I remind the court, as you know from the other briefing, the recall was in 2021. So all these hearsay statements are not only hearsay, they're not even contemporaneous with the consumption. They don't give us any indicia of faith that they're accurate. It's just a number of things that don't exist. And to say, well, you know, he lived above this or he owned this, I subpoenaed Gamstar. Gamstar owns Spring Valley Market. You saw the picture of it. I'm not going to ask Shane to put it back up. I found it interesting. There was a psychic there on the board. And what did we not have, Your Honor? Receipts. Receipts. Mr. Herbst is a businessman. He's very particular, and he's methodical, and he keeps all this stuff, and Ted was very honest about that. And as the administrator of the estate, she's the de facto owner of Spring Valley Market. At least she was when I deposed her. And we subpoenaed them and said, hey, show us your records. Show us it. And we started our brief, which I skipped over because it was really easy for Your Honor. And I skipped over it and I said, they don't have receipts. They don't have purchase stuff. Where is it? And I got 400 credit card purchases of real water from them that were made from Spring Valley Market. I got 0 cash receipts. 0. Under Rule 37, they can't argue it. They can't offer it in court, and we all know if it's not admissible in court, it can't defeat summary judgment. So what are we left with? Gossamer threads, at best, of whimsy, speculation, smoke, mirrors, believe us. Him carrying a newspaper in 2024 is not just hilarious, but it's completely devoid of, well, he bought it at Terrible Herbst. When, I don't know, because we know it's been off the market for 3 years. You've got to enter summary judgment, Your Honor. They can't prove actual causation. They can't say he got real water from Terrible Herbst. They can't say he got real water distributed by Nevada Beverage. He's not here. Everything that we've heard is at least single hearsay and not enough to defeat summary judgment, at least as to Nevada Beverage and Terrible Herbst. And I would ask the court to take a hard look at that. Not just would-be Safeway, but Wilson v. Circus, Goodrich, all the but-for causation cases, and of course, the holy trinity of expert cases being Williams, Morsicato, and Hallmark. And Dr. Kahn doesn't cut it. The video of him carrying a newspaper 3 years after real water was taken off the market doesn't cut it. Nothing cuts it. And summary judgment is necessary and appropriate, and I thank you for your time.
Thank you. Any other?
Just briefly, Your Honor, Jim Cavanaugh for ETT1 DBA Terrible Herbst. As Mr. Pepperman was going through the testimony and repeatedly mentioned my client's convenience store chain name, Terrible Herbst, that wasn't what was showing up in the lines of testimony. I don't know if the court had a chance to recognize that, but it's not there. When we actually deposed these folks and asked them about Terrible Herbst, The one person I recall, I'm not sure if it was Ron Murphy, but I asked him, well, did he even ever tell you he purchased water at Terrible Herbst? And it was, oh, well, yeah, the summer he died, 2024. When was that? Well, told me and some other people at the hardware store. We didn't know the name of the hardware store. He didn't give it to me. Well, who were the people you were with? I don't remember. Well, just give me a name of one person that you were talking to at the hardware store that told you he bought real water from Terrible Herbst. Couldn't think of one name. And most everything you're being told about testimony that corroborates other hearsay testimony, it's just not there, not with regard to a specific instance of purchase from Terrible Herbst. Now today, for the first time, I'll be darned, I can't find it in the written discovery responses they served to me that I was mentioning earlier, that they served November 20th, but someone named Mike Lucas, or Michael Lucas, Lucas. Well, he doesn't appear in the 9 names they say. Here, this is our proof of who will testify that he purchased real water from Terrible Herbst. And
Is he in the?
Michael Lucas?
He's in the opposition, right? But he's in the brief, right?
Correction, I don't.
Is he?
What brief would that be?
No, one of the,
What day was that brief?
And I'd also point out that,
well, hold on, it's not your. Oh, so you're asking me, I have 2 huge binders
I'm
right in
sorry.
front of me. What day, I do believe that, because I remember reading this stuff, you know, the picture, the quotes from the non-party witnesses to the effect of he drank real water. So if you're asking me what page that's on and which brief it's in, I don't know.
I get it. I'm not asking you really that. I just was wondering if you had a date. I believe these motions for summary judgment were filed weeks before the final responses to my request for production, and I represent to the court. Mr. Lucas is not listed as this witness who's they're obligated to tell me is going to be proof of the purchases for Terrible Herbst. It was an oversight, no doubt, but I don't have it. And again, discovery's not completed. We have to do more on that. I won't re-argue that motion, but that's just another example of nothing to see here except for there is apparently, but we're not being given what's there to be seen. Again, I just really wanted to underline for the court, my client's convenience store name is mentioned repeatedly as Ms. Pepperman was going through his presentation, and it's just not there, not in testimony, not in eyewitness testimony to things that happened, except for this declaration that was not in there, any of their discovery responses, including what they served November 20th, 2025. And thank you for your time, sir.
Thank you. Oh. So, as to real water and Terrible Herbst, partial summary judgment is granted against those 2 defendants on the issue preclusion basis. And to be clear, when we're talking about liability, that's better defined as follows. You know, 1, the defect of having hydrazine in the bottles. 2, that the defect of having hydrazine in the bottles existed when the left defendants' hands. It's not to causation, and that includes but is not limited to certainly whether any particular plaintiff, including but not limited to Mr. Herbst, drink real water. Oh. The court denies without prejudice the counter motions of joiners because genuine issues of material fact exist and set forth in detail in the briefing and arguments today. And, where are you coming back in front of?
Judge, we got one motion left, which I'm not trying to say we should argue.
I
I just wanted to point out. Okay.
Or it's time for the day, but,
Is there two left?
I think that I was gonna, there's two, right?
Yeah, there's
Well,
I'm sorry.
I think the estoppel one is moved based on the ruling on the.
I would agree with that, well, as to real water and terrible.
Yeah, I mean, it was based on real water statements, so.
Oh, and I forgot this. So the primary basis for the issue preclusion is to be clear, or maybe at least Judge Kishner's order. Same issue, same parties, decided on the merits, final judgment, actually necessarily litigated, parties the same. I'm not issuing this to Nevada Beverage at this time. And yeah. You're coming in front of me on December 17th.
I think we are now.
January 5th. Is that what you have? December 17th. Let's see, one of my med mals just settled, so that's good.
That's how many there are, right?
Do we know which med mal today?
Your Honor, what's on the 17th?
Pre-trial conference calendar call. Pre-trial and calendar.
What's that?
Same date.
I think we might have, is that one of the new dates?
No, that's the counter.
Yeah, it's kind of.
Your Honor, just to be clear on that date, given that the pretrial motions are pending and the trial date is January 20th, is it all right if we not have all the requirements under the rules that are due on the calendar call and address that at a different date, or is that something you're still looking for in the calendar call?
At the risk of relying on you all, to answer your question, no, you do not have to bring everything with you at the calendar call. Yes, I anticipate we will have a supplementary calendar call probably on January 5th. Does that answer your question?
Yes, Your Honor.
I'm trying to find.
The one that settled was set for the 5th, instead of Legacy was.
On the 17th, I've also got a bunch of motions and another med mal, but we'll put your potentially two, potentially only one on for the 17th at 9 a.m. as well.
Eric, are we treating the judicial estoppel as moot, given the order?
Yes,
We'll step to that,
And
okay.
and you all can make sure you double check with each other, you don't have to agree to that right this second. But that's why I wanted to do the issue preclusion one before the estoppel one, candidly, but see you in a couple of weeks.
Thank you, Your Honor. Have a
Thank
good
you, Your
day.
Honor.
Thank you, I appreciate it.